Today, I want to talk about an extremely important case that was just argued before the Supreme Court. This case builds on previous unanimous Supreme Court decisions that protect our fundamental right to prevent unlawful, warrantless entries into our homes. I'm going to break down what happened during these oral arguments and share my thoughts on how I believe the court will ultimately rule. Before we get started, if you find this content valuable and want to support the channel, please hit that subscribe button. The case we're discussing today is Case v. Montana, and it centers on when police officers can legally enter someone's home without a warrant. What makes this case particularly significant is that it attempts to build on a previous unanimous Supreme Court ruling involving warrantless home entries. For gun owners especially, this case deserves your attention because it addresses whether law enforcement can use certain legal workarounds to not only enter your home without a warrant, but also potentially seize your firearms in the process. After listening to the oral arguments this morning, I believe there's a good chance this will turn out favorably. I expect the Supreme Court to reverse the Montana Supreme Court's decision, though there will be some important details in how they do it. This case attempts to expand on two major Supreme Court precedents, Caniglia v. Strom and Brigham City v. Stewart. Both were unanimous decisions that set important boundaries on when police can enter homes without warrants. The facts of this case are fascinating and troubling. Here's what happened. Trevor Case's ex-girlfriend called the police after receiving a phone call from him. She told police she had a bad feeling about the call. She said she thought she heard what might have been a firearm being racked, and she heard a popping sound, though she wasn't entirely sure what it was. When she and the officers arrived at Trevor Case's home, she admitted she couldn't actually remember exactly what he had said during the call. However, she told officers she had a bad feeling and suggested he might want to have a shootout with police. The officers already knew Trevor Case. They were familiar with his history of mental health issues and had responded to calls at his home before where nothing ultimately happened. When police arrived at the residence, they looked through all the windows into various rooms but didn't see Trevor Case anywhere. One officer noticed an empty holster with no handgun in it. They also saw a notepad and some empty beer cans inside the home. The officers knocked on the front door, shined flashlights through the windows, and called out for him. There was no response. After spending about 40 minutes at the house, the officers made the decision to enter through the unlocked front door. One officer went upstairs to a bedroom. He saw a closet curtain suddenly jerk open. The officer said he saw Trevor Case's face and what appeared to be a black object. In that moment, the officer fired his weapon, shooting Trevor Case once. The bullet went through his arm and struck him in the abdomen. After the shooting, they called for medical assistance and recovered a handgun from a laundry basket in that upstairs bedroom. The officer who shot Trevor Case fired within 0.4 of a second, a single shot. He later stated it was essentially a startled response. He saw the closet curtain jerk open, saw movement, and fired. Trevor Case argued that the officer's warrantless entry into his home violated the Fourth Amendment. Therefore, he contended, the gun and any other evidence found should be suppressed. The lower courts rejected these arguments. Eventually, the Montana Supreme Court also rejected them in a 4-3 split decision. Here's where things get interesting. The Montana Supreme Court didn't use the standard established in Brigham City, which the U.S. Supreme Court had previously laid out. Instead, they appeared to apply a lower standard, something closer to reasonable suspicion, or possibly even less than that. Because of this deviation from established precedent, the case was appealed to the United States Supreme Court, which granted review. Oral arguments took place this morning. In his petition to the Supreme Court, Trevor Case argues that the Fourth Amendment's probable cause requirements should apply to these emergency aid situations where police enter a home. Both the Trump administration and the state of Montana argue against requiring probable cause in the emergency aid scenarios. In fact, the Trump administration has asked for what they call a sliding scale approach based on reasonable suspicion. Their argument is that this gives police officers more flexibility to respond effectively in emergency situations. To understand what's at stake here, you need to know what the Supreme Court said in Brigham City v. Stewart. In that case, police responded to a complaint about a loud party. When officers arrived, they saw minors drinking outside and heard shouting coming from inside the home. As they approached, they looked through a window and saw a juvenile fighting with 4 adults. One of the adults punched the minor hard in the face, and the officer saw the minor spit blood. The officers announced their presence, but nobody heard them because of all the noise from the party and the fighting. So they entered the home and arrested the adults for providing alcohol to minors and for assault. This case eventually made its way to the Supreme Court. The Supreme Court issued a unanimous ruling establishing that police may enter a building without a warrant when they have an objectively reasonable basis to believe that an occupant is seriously injured or threatened with such injury. What happened during today's oral arguments? During this morning's oral arguments, many of the justices focused heavily on the fact that the Montana Supreme Court failed to properly apply the Brigham City standard. Instead, they used a lesser standard of reasonable suspicion or something even more relaxed. At one point, Justice Barrett actually mocked the Montana Supreme Court for what she called a very sloppy opinion. It seemed clear that the majority, if not all of the justices, agreed that the Montana Supreme Court got the analysis wrong. The real question now is what the Supreme Court will do about this improper ruling. Several justices asked whether they should simply vacate the Montana Supreme Court's decision and remand the case back to them, essentially telling them to apply the Brigham City standard correctly. The other option they discussed was whether the Supreme Court should decide the case itself, looking at the specific facts of Trevor Case's situation, applying the Brigham City standard themselves, and providing clear guidance to all lower courts. I should mention that Trevor Case's attorney primarily focused on arguing that the Supreme Court should apply the Fourth Amendment's probable cause standard to these emergency aid cases. However, I don't believe any of the justices were inclined to go that route. Many expressed concerns that a probable cause standard would be too difficult for police officers to apply correctly in the heat of the moment during actual emergency situations. Several of the conservative justices worried that it could prevent officers from doing their jobs because they wouldn't know how to properly apply that standard in real time. I believe there are 2 likely outcomes, and both result in the Supreme Court reversing the Montana Supreme Court's decision. Option 1. The Supreme Court simply vacates the Montana Supreme Court's ruling and remands the case back to them with instructions to properly apply the Brigham City standard. Option 2. The Supreme Court reverses the case and issues its own ruling, applying the Brigham City standard to the facts of this case and providing detailed guidance to lower courts on how to handle these emergency aid situations. The test they would likely apply asks whether police officers had an objectively reasonable basis to believe that an occupant is seriously injured or threatened with such injury. That's the standard from Brigham City, and many of the justices seem to indicate that this standard should apply to cases like Trevor Case's as well. Ultimately, I think this will be a unanimous decision vacating the Montana Supreme Court's ruling. Where the nuance comes in is with possible concurring opinions. If the court simply vacates and remands without issuing its own ruling, some justices might write concurrences saying they agree the Montana Supreme Court got it wrong, but believe the Supreme Court should have issued its own complete ruling and applied the standard themselves. Alternatively, if the court does issue a full decision applying the standard directly, you might see some variation in how different justices think about the details. Either way, the result appears certain. The Montana Supreme Court's ruling in this case will be vacated because they didn't apply the correct legal standard. This case gives the Supreme Court an opportunity to clarify and expand on its previous unanimous rulings on warrantless home entries. The implications are significant for all of us. This case will directly affect what protections we have against police officers entering our homes without warrants and using exceptions like emergency aid as justification. When these entries happen, sometimes bad outcomes follow, as we saw in this case. Looking ahead, those are the main takeaways from the oral arguments that took place today. We'll be watching closely to see how the Supreme Court rules. They have until the end of their term to issue a decision, so as more information becomes available and this case develops further, I'll keep you updated. If you found this breakdown helpful and want to support the channel, one of the best ways to do that is to subscribe.